Hey there, Bill O'Leary coming to you once again this Thursday afternoon. And this is, for those of you who have not come across this before, this is what we call our Thirsty Thursday series. So every Thursday at about this time, what I'm going to do is jump on and talk about a topic that might be interesting that relates to, estate planning, elder law, that sort of thing. So if you are thirsty for knowledge, you have come to the right place. So today's topic, I guess I'll ask this question. Can the beginning signs of dementia, could that be a good sign that it's time to start planning for your future? So look, when you make financial and healthcare decisions in your estate plan or as part of your estate plan, you have to be of sound mind to do this. And it makes perfect sense. This is, after all, for your protection, to make sure that no one's taking advantage of you and that the decisions are yours and yours alone, and that these decisions have been, thought through. But if you have dementia, you lose this mental capability. So, for this important reason alone, it's important to plan ahead when you're healthy and to act even more urgently if you suspect that maybe dementia is in the early stages. Look, you've probably seen extreme examples on TV where, a person with dementia, they can't remember their own spouse or even their children from one day to the next. It's sad, and my mother has dementia, and sad to say, she doesn't really recognize me. All you can do is just be there for her in the moment. But really, long before the person gets to that stage, where they can't recognize family, dementia may cause problems with memory and complex reasoning. And the symptoms are often hard to spot early on, but they do get worse over time. And really, there's no cure. There's nothing you can do other than to prepare while you still are able and have your full mental abilities. Plan ahead. When you or someone, let's say, is someone that you love is diagnosed with dementia, which, by the way, is a progressive disease, you face a number of serious considerations, and many of those have to be made quickly. Has a chance to progress. So, in addition to decisions about the kind of care, a doctors, medical treatments, and therapies, this is the time early on to make some legal decisions to plan for the future. The fact is, the sooner you create an estate plan, the greater the likelihood that your loved one will be able to express his or her full wishes, which is a way to ensure that their estate plan is exactly what they want. Okay? So here's some tips and guidelines to help you through the process. It's painful to think of a future where you may suffer from dementia, but if you don't plan for that possibility, you not only put your estate at risk, but you may also put your family and your care at risk, because once dementia reaches the point where the person can't understand their assets, they can't understand the purpose behind any legal documents that they may have to put together, or maybe even know who their family is, at that point the person can no longer create or modify an existing estate plan. And once the dementia has progressed that far, the only option the family has is to file a guardianship with the court, petitioning the court to be appointed as the guardian of your loved one, and that becomes necessary if your loved one didn't get around to executing a power of attorney early on in the process, while they still could, a power of attorney where they give a loved one that they appoint as their agent the authority to make important decisions financially, or on the healthcare side, a healthcare surrogate nation. Okay? Now, the fact is, there's no clear line for when dementia may cause you or your loved one to lose official legal capacity to make decisions on your behalf. The general rule for legal capacity is, number one, you have a sound mind. Number two, you understand what's going on. Number three, you understand the impact of your decisions. And number four, that you're not sort of easily influenced by others. This is a decision that a judge may have to end up making with the help of doctors, okay, if it gets to that point. So So if you're diagnosed with the early stages of dementia, it's important to act quickly while you still, again, have the mental capacity to make the plans you need to. And again, your doctor can help and your family, they can determine the sufficient mental capacity that someone may have before the need to step in. Your medical records can also approve the validity of your will and your other estate planning documents if someone later comes in to challenge them, okay? And which they might if you wait too long and maybe you don't have the ability or capacity to sign those documents anymore. You don't want to wait that long to where someone can come in and question things. So good legal planning basically involves three factors. Number one, planning for your health, including long-term care needs. Number two, planning for the overseeing of your finances, your assets, your property. And number three, choosing someone to make important decisions on your behalf, both financial and health. So within these broad categories, there are a number of decisions and legal documents that really apply and are needed. But again, the end goal of any good planning is the same: to make sure that the individual with the diagnosis is cared for well and what he or she wants when the disease makes it impossible independently. And it's also designed to make sure that the person estate distribution is properly planned for to avoid complications and disagreements among family after death. Everything should be in proper legal form to avoid disputes between family members. In case that may have diminished capacity, you may ask for something that maybe not in your best interest. So here are some of the tools that you might want to consider. Number one, having a power of attorney, what's called a durable power of attorney, where you appoint someone to make important financial decisions for you. Number one. Number two, a healthcare surrogate designation. You appoint a healthcare surrogate decision maker to make healthcare decisions for you if you can't anymore. Number three, a living will is a way for you to express your wishes for the kind of medical care or treatment that you want, maybe given if you're close to death or have a terminal condition, something like that, or maybe that you don't want, maybe that you want withheld. Maybe it could be referred to as the, hey, I don't want to be put on machines legal tool. And number four, something called a living trust, okay, which is a way for you to decide who gets your stuff, when they get it, and how they get it. And a living trust, it's a replacement for a last will and testament. And living trusts are great tools to make sure, number one, your family's not stuck in the probate court, and for as long as that takes, and it's very expensive. And two, it's a great way to protect the kids' inheritance, maybe from them getting divorced so that their inheritance is gone, them getting divorced, or think of sort of the liability lawsuit, let's say they get into a car accident. There clearly is no one size fits all, and what you should do will depend on your exact wishes and your exact situation. Okay? Now, let's shift gears for a minute. Because the dementia can affect an individual's sort of cognitive function and the memories, the person that has the disease, again, as I've said, may not be able to handle these legal decisions, independently. So often the legal planning for someone with dementia should be a family affair, because children or siblings may have to step up and provide help in making those decisions. So who are some of the people that should be involved in this process? Well, one, the individual with the early stages, with the diagnosis. They need to be involved in the process to the extent that they can contribute. And again, even if the disease has progressed, if you will, to the point where their ability to make decisions is somewhat in question, they should be consulted when appropriate to make sure that their planning is in line with their goals and the desires. Because even somebody with that condition can sort of come in and out and will have periods of lucidity, more lucid moments than others, and you want to hear them during those lucid moments. Number two, the person's spouse. For married individuals, they have a spouse that's still living. The spouse should be part of the legal planning process. This is so important because most of the times, a married couple, you're talking about assets that are owned together as husband and wife. Third category, adult children, okay? Great people to have involved, okay? Because they can be included in the decision-making process, providing they have a good and loving relationship with their parent that has the diagnosis, okay? And again, children often will have the best interests of their parents in mind, and they'll know what their parents' goals and desires are. How about the individual's attorney or the lawyer? If they have one, they should be involved in the process as well, because often lawyers, are privy to information about the individuals that others, even family members, may not know about, and they can bring a certain legal perspective to the table. And then number 5, how about other relatives or close friends? Again, they may have a unique insight into the person's wishes, and maybe they can participate in that process, particularly if they might end up being named as a trustee, an executor, or a power of attorney. So, with all of that said, it's possible that you can have too many people participating in the process, and sometimes that might get confusing, okay? So while others could be consulted, ultimately the decision should be left to the individual if they're able to make that decision, or their family members, okay? And by the way, what if you're married and it's not you that has the diagnosis, but it is your spouse has the dementia diagnosis? Well, just because your spouse has dementia doesn't necessarily mean they're going to die before you. You might unexpectedly die first, okay? And there's also no guarantee that that you will remain healthy enough to provide for your spouse's care. So while your spouse, the one with the diagnosis, certainly needs to prepare an estate plan, so do you. So do you. So I hope you enjoyed this talk about the beginning signs of dementia. It's often a good time to start the planning process. If you'd like to know more about that and maybe how we can help, we'd love to talk to you. Okay, so you can book a free 15-minute phone call with us. You can just go to our main Facebook page, click on the Book Now button, and it's very easy. And this 15-minute call, will give both of us a chance to see whether we'd be sort of a good fit for each other, and also give us a chance to tell you whether we can help you. So again, you can use the Book Now button on the Facebook page. You can just Google us, legacyplanninglawgroup.com, or call us at the office, 904-880-5554, and Cindy, in all likelihood, will answer the phone. You'll love talking to Cindy. So again, I hope you've enjoyed this talk about whether the beginning signs of dementia it is sort of a good time to start the planning. As I said at the start of this, I plan on giving another Facebook Live talk next Thursday at about the same time. Same day, same time, different topic. So again, if you're thirsting for knowledge, we will quench your thirst. So this is Bill O'Leary signing off on behalf of everybody here at Team Legacy. Go make it a great day.